Hi everyone, thank you for watching this lecture. Today, Neha and I are going to talk about this year's 2025 policy topic. So, yeah, we both do policy debate, and yeah, cool. So this is this year's resolution. The United States federal government should significantly strengthen its protection of domestic intellectual property rights in copyrights, patents, and/or trademarks. So today we'll just go over a few topic areas. So we'll talk about just a general overview of what intellectual property rights are, and then we'll also hi. Today we'll talk about what intellectual property rights are, and then we'll talk about the specific topic areas. So we'll talk about copyrights, patents, and trademarks. Yeah.
Yeah.
Okay.
Oh, okay. So IPR for short, or intellectual property rights, refers to the creations of the mind. So that includes things like inventions, like light bulbs and stuff, literary and artistic works, which are associated with things like copyright, designs, symbols, and names and images used in commerce. So you'll notice these things are all bolded because they fall into like different topic areas that we're all going to talk about here. But all of these things are protected by the US Constitution. Fun fact, IPR is the only thing, or is one of the few topics that we have that discusses a constitutional right. So we have the right in the United States constitutionally to protect our own thoughts, ideas, inventions, etc. And what do we do to protect them? We protect them from infringement, which looks like IP theft by foreign actors. You're going to see a lot of like cards and evidence about how like other countries like China is stealing like our intellectual property via like patent disclosures or just like seeing patents, etc., and then stealing those inventions, which is bad. And then there's domestic theft by large corporations. So think like appropriation of like smaller beauty brands like designs by larger creators. And then how we remedy this is through money and through litigation. So you will go to court and you will file for relief because you've been infringed upon, and you'll get injunctions, which means that they'll pay a fine or something and then they'll stop using your IPR, or you'll get the settlement beforehand, which usually is like an agreement by two parties to not go to trial. But a lot of people just like delaying that.
Yes. And there are a few types of injunctions. There are temporary injunctions and permanent injunctions, which we'll talk about a little bit more, I think, on the patent slide. But if there are any questions, like just unmute and ask them or put them in the chat. Okay, so patents. So patents are a government authority or license conferring the right or title for a set period, especially the sole right to exclude others from making, using, or selling an invention. So patents are for things that are invented, and I think most of the bigger AFs on this topic have like stuff to do with patents. And there are a few core controversies, which I'll talk about in a second. But there are a few requirements for things to be patentable. So there are 5 of them. So the first is patentable subject matter, and that's going to be probably a pretty common like AF area in terms of patents, at least, and just in this topic in general. So what can be protected under and included in intellectual property? So does it qualify as the things listed? The second is utility. Can it actually be used for something? Third is novelty, which is whether or not it's new. 4 is non-obviousness. This one's kind of random, but you don't really need to know anything about it. You don't, yeah. And then the 5th is enablement. So the last two, they don't really need to you don't really need to be concerned with them, I don't think, unless Neha, you have a different.
I mean, like, there's a couple apps that like talk about that, but it's like if it's non-obvious, then that means like obviously you can't patent like the fact that the sky is blue. So that is like an example of non-obviousness. And then enablement is low-key irrelevant. So yeah.
Yeah, they're not really super important. But there are a few key controversies. So the first is the Alice Mayo framework, which basically is like a series of court rulings that established what is considered patentable and what is not considered patentable. But the set of rulings basically created a vagueness around whether or not new things can be patented. So things like software, for example, it's kind of vague whether or not stuff like that can be patented. So there are a few AFs that kind of clarify the Alice Mayo framework. And and one of those AFs, for example, is PARA, which is the Patent Eligibility Restoration Act, which is just it was proposed to Congress, in Congress, I mean, and it would clarify and overturn some of the holdings held in Alice Mayo and those other cases that are relevant. But that AF area would probably expand subject matter eligibility. And then the second is eBay v. Merck Exchange, which established a 4-factor test in terms of how easy it is to get injunctive relief. So what I said earlier, there are a few types of injunctions. There are permanent injunctions and there are temporary injunctions. But you'll see here on this topic, there's a lot of ground, I guess, regarding innovation, especially big companies and big corporations versus small companies and whatnot, and how those two sorts of entities interact. So you'll read a lot about how big corporations, like what Neha was saying earlier, take advantage of or infringe upon smaller companies' inventions and stuff like that. And big corporations are often really rich and they have a lot of financial means and the means to just pay all the damages. But a permanent injunction would make it basically eBay v. Merck Exchange made it hard to get a permanent injunction. So small businesses cannot stop large corporations from basically just infringing indefinitely, because a permanent injunction would mean that the corporation that's infringing can not make the your patented object ever, versus a temporary injunction where it's only for a certain amount of time. But obviously we want to make, or the AF would argue that we want to make it easier to get a permanent injunction. So we would presume irreparable harm, which is the fourth tenet, I believe, of the 4-factor test. So that's basically what one AF example does in regards to eBay v. Merck Exchange. Patents last for 20 years, I'm pretty sure, and it grants you sole monopoly over a certain your certain object. So you have the right to control that means of production and stuff like that. But yeah.
Okay, so this is copyright. Copyright lasts for, I think, the year, like your entire lifespan, so however long you live, plus 75 years. And it protects original works of authorship or an art, etc. Like authorship does not just have to be writing. So you could make a painting and it is still authorship, I guess. And as soon as that author fixes the work in a tangible form of expression, it then becomes copyright protected. So that means you can't just like copyright the idea of a painting. You have to actually make the painting to get the copyright over it. And so copyright actually exists informally for anything that you've created. So all your school essays, everything, all of that is your own work. And if anybody infringes upon that, that is copyright infringement. And you can actually file lawsuits for that if you can prove that like it was yours. But the ones that we're going to be talking about are the ones where you can protect copyright physically by registering it with the United States federal government. So why we register things and why we protect them officially is to incentivize like artistic expression. And so that's what she put here is like this quote about how like Congress wanted to promote the progress of science and youthful arts. So if you were a musician and your music kept getting stolen by large corporations, you wouldn't be like quite so incentivized to create anything else. So it becomes useful to have that protected. And fair use at the bottom is important because there's a lot of controversies over this and like deepfakes, AI, etc. But it says that if you are using the copyrighted work without permission, you are allowed to do so. It is not infringement as long as you're using it for criticism, comment, news reporting, teaching, scholarship, or research. So anything that is meant to educate or speak on a particular subject that uses your artwork is fair use. It becomes a little bit murky when companies have a lot more power than one another. So, like if a small business has seen a large business do something with their product and the large business claims that it's fair use, but it's clearly not fair use, it's hard for that smaller company to actually kind of protect their own IP. Also, fun fact, Alena just fair used this quote because she took it from the internet. And the New York Times versus OpenAI stuff was about how like journalists and like articles, etc., were being taken and used to train AI. And that's an example of where the area of fair use is murky because yes, it's being used technically to educate an AI, but it's being trained off of intellectual property by real human beings. And that intellectual property is getting reappropriated into short AI blurbs at the beginning of Google and stuff like that. So people aren't necessarily reading articles anymore, and that's affecting authorship and stuff like that. So there's a lot of asks that are going to talk about AI copyright specifically and expression. And then I guess like another area that you would have to know is that like people are going to talk literally about like the marks themselves and what they are of. One AF from I think the UMich camp that was put out was about indigenous copyright, and that prevented the appropriation of indigenous forms of expression by considering another factor in how we protect things via copyright. So a lot of it is about like artistic expression and its effects. So it can be really good for areas where you want to debate like a K team, but you're not really sure what AF to read. It's a lot easier to get like more soft left impacts in this area because it's less related to like the like patents and trademarks and like exclusionary forms of expression because this is like solely based on art.
Yes, agree. I know DDI put out a few, or like brainstormed and put out a few critically topical, as I would say, affirmatives about copyright and that sort of thing. But I agree, it's definitely strategic for those sorts of things, whereas I think you'll find that with patents, you'll be seeing a lot more big stick affirmatives with bigger impacts. Yeah, they're like what Neha said earlier. You can either like you can have your own copyright, or you can just like you can file. And there's a similar thing with trademark. So trademark is a word, name, symbol, or design, or any combination used in commerce to identify and distinguish the goods of one manufacturer or seller from those of another and to indicate the source of those goods. So there are a few types, or like, okay, you can trademark two things. You can trademark like a brand or a service. And the goal is to help consumers differentiate between brands and services and like products. So logos and slogans are example. So, like the Nike swoosh is trademarked, and you can also, like copyright, you can also kind of just like slap a TM onto your original logo, and that's technically trademarked. But if you file for a trademark with the government, then you'll get the R in a circle, and that has a stronger protection on that thing. So I'm not sure, like counterfeits, for example. So if the Nike swoosh is trademarked, for example, if the swoosh is backwards, then it's like Mikey instead of Nike, then that would be an example of counterfeit. So there are a lot of ways that, counterfeiters kind of try to maneuver around trademark laws. So there are a few areas, I guess. So counterfeits is one. The internal link chains for this have been dubious. Perchance there's a lot of stuff about like how that would affect supply chains, but
Yeah, there's that, and then apparently they cause kleptocracies.
Yep.
So that's certainly something.
Yep.
But more power to you if you want to read that up.
Yep. Definitely go digging there more. They're trademark bullies. There are things like subject matter that, like things that haven't been trademarked yet that people want to make eligible to be trademarked. So like marijuana brands. I know that was a popular app at DDI. But yeah, so there's stuff like that. And then if you look at the word bullies, there's a lot of different types of like bullies in terms of IP. So yeah, okay. So we can talk about the neg stuff, but actually one last thing on patents. So the reason why patents are so, like all the apps are saying that patents are crucial for like unique innovation to solve like their like China tech race impacts, or like I don't know, bio whatever
Tech.
biotech, etc. So patents, the third requirement, novelty, is very, very important. So things have to be new and they have to be truly innovative. And one very important part of the patent process, so for trademarks and copyright, you can just slap like a TM on it and it's like boom, trademark. You don't really have to file through the government unless you want like stronger protection and you want it to be government protected. But in order for something to be patented, you actually do have to go through a very rigorous filing process, in which case you have to disclose everything about how you made this product. And then the like PTO, so the Patent and Trademark Office, will rigorously examine your submission to determine whether or not you qualify for a patent. And the reason that they have you disclose your process in making your invention is so that it promotes the third tenet of novelty. So when and it incentivizes more innovation. So when people see what other people are filing for, they know whether or not they know what they can and cannot innovate, or it kind of guides them a little bit in terms of what more they can innovate. So things like there's like follow-on innovation, which is where you kind of look at an initial product and then you modify it enough to make it novel, but it was inspired, or like you created it based off of a previous invention. But generally, it just, makes the process of innovation over a certain period of time more productive or progressive, I guess, more innovative. So that's what the patent filing process is meant to do. But obviously, all these companies, patent holders, trademark holders, copyright holders, they all have huge profit motive, right? We live the US private market economy, and all these private companies, they have profit motive to, make a design that they know will be profitable, and their investors want to know that they'll be getting returns on their investment. So if they won't know whether or not their invention will be patented, then that discourages them from filing, which leads to things like trade secrets, where there's not as much disclosure because people just kind of share secret information about how to make this or that, and they will sign NDAs and stuff like that, which would obviously decrease people filing for patents and stuff like that. So that's just like the background, I guess, for the bullying thing, which we'll talk about with neg arguments.
Yippee. This is fun. So neg ground, yeah. It's actually not fun because there's nothing. But you can ban them. You can ban all the IP. You can ban trademarks. You can ban patents. You can ban copyright, and then generate uniqueness for a diss ad, which is so fun because all of the diss ads don't have uniqueness right now. So that would be great if you could do that. Advantage counterplanning out of things. Obviously, there's like the generic advantage counterplan file that I know most teams have it sitting in their back pocket, where they just pull out random planks about sunshades and then solve global warming somehow. But there's topic-specific counterplans like the prizes counterplan that was released at UMich that offers a public incentive system rather than a patent. So it offers a prize, aka companies competing for like a monetary reward calculated by the government in order to have the money because that was their incentive in the first place, and B, have the government recognize their invention and then getting all the credit and the rewards for it, which functions similarly to a patent, except they do not get the short-term or long-term monopoly over the product. And then the R&D counterplan, you can do public funding for R&D. There's a lot of good research that like NASA, public laboratories, university laboratories are all better at innovation than private laboratories. And those can all be substitutes for IPR itself, because a lot of the internal links to every single app will just be, we need innovation. Well, why do you need patents? That's the question that they can't answer. Sui generis. This is an awkward one because sui generis means literally anything under the sun. It means unique. If you go on Google and you search up unique synonyms, you're going to get sui generis as one of them, which is really weird because I didn't think that ALB was being like super for real when she said that. But yes, that's actually true. You can put this next to literally any area that the AF does IPR over, and there'll be a Google search that comes up with some sui generis system for it. And that means that like the systems can look anything like public and private agency cooperation, or creating like sectors of government designed to protect intellectual property over this one area. I know for semiconductors, they created a rigorous test to determine whether or not these chips would be able to be protected by IPR. And a lot of it is unique to the specific sector that you're in, because sui generis is meant to offer a more specific industry-specific solution to the apps areas. So if you're researching this with the wise words of ALB, you're gonna do sui generis or bust. Like you have to put all your eggs in kind of the sui generis basket. And then obviously the capitalism criticism, because IPR is property, and ownership of property and private ownership is bad because it sustains the neoliberal economy. This one's pretty straightforward. The camps that, at least the Michigan camp, put out this weird property K thing with this epistemology alt. And I say, if you're going to criticize capitalism, criticize it by not being scared and fiating the alt, because you know that they're going to read the cards anyway, so you might as well double down.
For real. Yeah, I was talking to one of our sophomores who went to Michigan, and they were like, what is this neo-lib K thing? I was like,
Cap.
horrible.
It is.
I'm just kidding.
It is Brett Brigger's baby, so I'm not gonna shade it too hard, but like I think just fiat the alt low key, because like if you're doing a revolution, do it right.
Agree. Yeah, there's really not that much net ground on this topic, because the resolution, it's like flipped, because in the status quo, the US already has the strongest IPR system in the world. So any, like, literally the neg ground, like the neg does not get to defend the status quo anymore, is like essentially what the wording of the topic means, which is why you have to have all these like uniqueness counter plans and stuff like that. So advantage counter plans, i.e., a plank for prizes and a plank for ban, like that is your advantage counter plan. Sui generis, yeah, that's AF is probably mostly strategic against AFs that expand subject matter. So, for example, like the para AF, or for example, if they made software patentable, then you could be like, we're just going to make a totally separate regime called, like, I don't know. It's like literally so arbitrary. You could just call it like buttons regime or something like that.
Yeah, you could name it. We could name it Brett Bricker for the property K.
Yep.
Yeah. It literally means nothing.
Yeah, and what Neha was saying earlier about how you really have to just, well, in the words of ALB, how you really have to put all your eggs in one basket. The sui generis counterplan, or sui generis, whatever.
Yeah, I don't know.
Well, and I don't know Latin either, but it is very intense literature. And this year's topic is very heavy on the legal jargon. I feel like, every year, we have one topic per year. We become mini experts on this topic, but I think for this year's topic especially, it's very sink or swim. Like, you have to do your reading, or else you're just going to be totally lost the entire time. Like,
yeah,
I don't know if it's just me, but I had no clue what anything was when I
no. And the first like 3 weeks at the Michigan camp, like nobody knew what was going on. People in cross-ex were like, how does sui generis compete? I don't know, because the system's sui generis and you do a patent, and that means nothing.
I know. It literally is just horrible, the negative arguments. Here, okay, we can talk a little bit about T and disads, because I didn't put anything there because, like, there is nothing.
Yeah, I mean, I guess like the disads are like AF specific. Like if an AF does Alice, you can say Alice bad. And if they do Mayo, you can say Mayo bad.
Yeah, I honestly think like case turns are pretty decent.
Yeah.
If anything. So what we were talking about a little bit about bullying earlier, PAEs and like patent trolls. Basically, there are a lot of corporations that have like a lot, or patent thickets. Companies will hold a bunch of patents to protect any innovation in that sector, because they want to like have monopoly over it, or they'll like just like keep filing for patents on like a marginal thing once their patent expires, so that they have monopoly over a certain industry, for more than the 20-year deadline. And obviously that can, strong protections can allow big corporations to kind of abuse their resources. And then PAEs, or patent assertion entities, who are also NPEs, which are non-patent entities.
Yeah, I don't
They're
like.
like, I don't know, it's really weird. Basically, all you have to know, they're they're like big companies who hold patents, but they'll just like infringe and infringe and infringe or something like that. And then every time a small business tries to sue them, they'll just throw money at them and say, okay. And then they'll just keep infringing.
Yeah.
That's like the bulk of the bullying. And
Oh,
those case turns are pretty compelling.
yeah, they have bullying on every topic area. So if you just put like copyright bully or trademark bully, you'll get the same thing except for trademarks and copyright, which kind of makes like the bullying and thicket stuff like core of the topic more than anything else.
Yep. Yep. I think
T subs is still a thing in terms of tea.
you can talk about that.
There's nothing to say. Like it's not even like core of the topic. I mean, there's tea courts like where you can't like you have to be the courts there, or you can't be the courts. There's tea enforcement where it means that like it's legislative action and that goes through like executive enforcement and it can't be court enforcement. So you can't like do a like overturn a court case and have the lower courts enforce it as like a plain text, I guess. But like I don't know, I feel like all these things existed on previous topics.
Yeah, the topicality literature on this year's topic is also pretty dubious, suspicious. I guess there's nobody really writing super precise definitions of these things, especially in terms of like what counts as protection. Um, and that sort of thing. So you can either do a race to have like a race to the bottom or just have a debate with like no net ground, basically.
Yeah, basically like
Um, but you know, that's fine. Debate still happens. Uh disads, um, you know, you have your generic econ disad, so I think inflation is pretty popular right now. I know. I didn't really go for that. Now, did you go for that?
I did. I was in my wanna visa here era. But like
What are like links, I guess, to the
a lot of it is similar to the case turn literature. So the fact that like people acquiring mass amounts of patents causes like price hikes, or one person having the ability to acquire a massive amount of patents causes price hikes in like certain areas, and that leads to an overall increase in prices of goods, which is bad because inflation is bad. So there's that. And then like trademarks, etc. When all of those things get overly enforced, they lead to monopolies, which leads to one person being able to control like an entire sector of goods. So a lot of it was just like bullying, trolling, thickets, evergreening, the usual stuff, and then that causing inflation and war. There was elections and there was politics for a short amount of time before it died. Um, elections is weird because voters don't perceive IP policy, but there is a way that you could run elections saying that voters perceive like the impact level of the AF or like the policy proposal level of the AF. So like voters perceive the AF's policy as like China bashing or whatever, and that could be good or bad. But yeah, those are the two, and elections is kind of bad, so
and elections will be dead after November. So
yeah,
I don't know if I would pour all my
eggs into that basket.
that.
Short-lived.
I guess there's like court clog.
Yeah.
Mm,
That's also like the litigation links. I mean, all the links on every single diss out are just so similar. It's kind
yeah. I guess like, oh, I forgot to define patent trolls.
oh,
Are those the same as PAEs? I got
yeah,
so
those are the same. Like they're like patent trolls, patent bullies, trademark trolls, trademark bullies, all of those things. They just like take a bunch of like patents or take a bunch of IP, they hoard it, and then they go to court for money because that's like their only goal.
yeah, they'll like claim other companies are infringing on their patent and then they'll basically just extract all the royalties from that litigation to keep the market anti-competitive. So there's a lot of like literature about like monopoly, stuff like that. I guess like answering in terms of like answering these neg arguments, I mean you can kind of assume like a core controversy, like I guess private versus public incentives for innovation. So the prizes counter plan and like open source alternatives and like
patent
picking winners, stuff like that. There are definitely a lot of cards about those sorts of things. So, for example, prizes probably, if the app has good internal links about why unique innovation and like disruptive innovation is key to solve their impacts. It's probably has something to do with the competitive nature of a private market economy and less to do with like Schumpeterian things, basically, i.e., the government picks an invention and they'll reward a prize to whoever can make that thing first. Because that's not necessarily innovative, because there's a lot of evidence that says that the government doesn't know what is best, but when private companies have incentives to compete with each other and try and make the best invention, then that is very good for XYZ reason, i.e., their app's impact.
Yeah.
But yeah, that's like
there's like no neg. Okay.
Yeah, like there's like not that much to talk about. Like, you know, it's a domestic topic. I guess you could read like multi-lat counter plans, stuff like that.
You could read sunsets, multi-lap. Those
offsets.
Yeah, offset the increase in the
Lengthening. Basically, just like any generic process counter plan on any domestic topic, you could probably use it for this topic.
Yeah.
You know, process counter plans, because the last few years the topics have been last year was okay.
Last year was good.
Yeah, you didn't need to read like a horrible process counter plan.
Core of the topic disads, and there were fun advantage counter plans that we could talk about, but there's no unifying ground over the topic areas. So it's a lot of like specific research that kind of literally won't help you unless you're facing like that specific AF.
Right. So this topic, although it might seem small because like last year there are only 3 core topic areas, there's a lot of different ways that people could approach each topic area, which means that you kind of have to, you know, manage your time, especially if you're from like a small school, in terms of what you want to prep on the negative. But basically, if you look up troll or like copyright, patent, or trademark plus troll or something like that, anything like that, you should be able to find links to some disad, and then you can generate uniqueness by banning IP. But I do think that like process counter plans are not your enemy. Critiques, the cap K is a classic, not your enemy.
Unless it's the property K, then I would say run the other direction and find the alt that does something.
Yes. You know, links determine the scope of the alt. Property is literally like the AF literally increases like the AF, like what Neha said, the Constitution explicitly protects like monopoly over your intellectual property. And whether or not your monopoly is like you're a big business or small business, you are literally given sole, like increasing protection means that you have more control over the means of production of your thing. So there's no reason for you not to read a link to the mechanism of a topical AF if it like increases things. I guess like if it's like a soft left AF, maybe then.
I mean, like, I don't know. I don't know. I've heard there's been a lot of Afropest v. native copyright debates, which is cool and interesting for links and ground. I don't know that much about it though. I haven't looked into it. And I've heard there's a lot of stuff for set call because property and obviously land back are not compatible. Yeah, and then like epistemological takes on property are always interesting. But again, like all of these things kind of really just evolve back to the idea that like property itself is bad for a multitude of reasons, whether that be contributing further to the market economy, contributing to like settler colonialist expansion, or just being like racist and bad in the system that was like grounded in racist ideology. All of
Yeah.
those things are like critiquable and things that people can read.
Yes. Oh, one thing that got put out by DDI, because this year's topic is about property and whatnot. You could probably read some version of Phil. I don't know how strategic that would be, but you could say Kant negates if you so please.
Yeah. Oh yeah. It's
Or like Locke, you could probably read something about Locke, I guess. But
oh no.
people probably won't be doing that. But yeah, so that's basically like the bulk of it. There's not like so much. I think like for me the topic was initially just very intimidating because I literally had no clue about anything relating to IPR, but I'd recommend just as like a starting point just going through the Michigan files or whatever camp files and just reading the starter pack to see kind of what topic generics there are this year.
Yeah. Or the lack thereof. Um
Yeah.
yeah. That and just like making sure you know all the terminology like and all the like intricacies of each topic area will probably make you sound a lot smarter and a lot more credible. Like, I don't know, like memorizing like sections 101 through 104 of patent eligibility is pretty interesting, especially section 102, since that one is about non-obviousness and that can answer a lot of this and that can answer a lot of disads for the AF about like patent thickets because some inventions will just be rejected because they're obvious or not novel. So just knowing what to research, looking at camp generics, all those things are helpful.
Yeah. But just to echo, biggest advice on this topic, read, just read, and you will be like, I swear that will make you just so much better. But if there are not any questions, like there are no questions, I'm assuming.
Yeah, I don't know. But I mean,
but yeah, that's basically it. Yeah, there's not that much on the negative to talk about because
yeah,
there's nothing to
there's nothing to talk about on the negative because nothing's ever going on.
nothing's ever going for the negative. Like,
I mean, there's a presidential debate tonight. I don't know if that changes anything about elections that's gonna die in like 2 months. Oh, thoughts on Kant. Alena, this is your domain, bro. I have no thoughts on Kant.
Are you like, have you done LD before and you've like gone for Phil or something like that? Like, is there any like particular thing you
Prior affiliations with
talk
Kant.
about with Kant? I think it's oh no. Yeah, of course, from the DDI squad. Yeah.
Oh.
I was there. I was part of that. I think okay, well, Kant I don't think people are going to read it. I would say basically Kant, you can kind of think about it like a critique in terms of how it's a different way that they propose we evaluate impacts. So Kant, just TLDR, Kant doesn't think we should evaluate consequences. He has this set of 3 rules called the categorical imperative. And basically, if you violate any of those rules, then an action is not ethical and you shouldn't do it, as opposed to evaluating consequences. And he has like thoughts on like property and stuff like that, like intellectual property, because Kant, one of like Kant's big ideologies, like he's from a pretty long time ago, and he was a very religious guy, and so he thinks his kind of like guiding philosophy is all humans have infinite value, and we shouldn't like use each other as like a means to an end or like stuff like that. So intellectual property is interesting because some would say that Kant would think intellectual property is like an extension of yourself, whereas others think that, oh, it's just like property. So that's like that sort of core controversy. But in terms of answering Kant, you'd probably answer it similarly to how you'd answer framework on the critique, kind of just like consequences are important. You can't separate your ethical intention from the consequences of that action, especially if you foresee the consequences of that action. So interesting. I'm definitely not the right person to ask if you're like thoroughly interested in going for Kant. I wouldn't
Yeah.
particularly. I don't know if I would recommend it because like I think I don't know what, like in LD it's a thing because that was like their whole foundation as a format, and then it kind of just like evolved into policy, but it also has like Phil because that's what it was initially. But I think like putting it in policy, unless you're debating someone who like does LD and is good at debating Phil and you have a judge in the back, I wouldn't be like super concerned. You kind of just make intuitive arguments. But you can kind of think about it like how you would answer the critique. But yeah, I hopefully like that part of camp was just catered towards like the like whole squad of LD people at DDI, but I don't.
Can't say we had any thoughts on Kant at Mish, but
Yeah, they would not let you. What would Zahir say about Kant?
I think Zahir would say that is an argument that people make to win, and he says winning is the ultimate goal. So
But I don't know if he'd say you'd win on that in policy.
I don't think he would. I think he would say go for it, and then he would clown on you when you do.
I agree. Yeah, I wouldn't. I don't know if I'd recommend that. I'd say just stick to like what you are comfortable with.
Not you being like, yeah, I keep your fill out of policy.
Yeah, I agree. I don't know why we're, bringing that in. It's like definitely an interesting literature base, and it definitely helped me like understand kind of how to debate framework against critiques, because it's such an extreme version of that. Basically, it's just like no consequences, period, and that kind of helped me understand like why utilitarianism works or doesn't work and like stuff like that, so I can have more in-depth nuanced debates about that thing. But beyond just like providing me with more information about that sort of thing, I don't know. I don't know how useful it's going to be to you otherwise. But yeah.
Any questions other than Immanuel Kant?